Welcome to Notable Approvals. I am attorney Amanda Shaffer. It's been quite hectic around here, so I haven't done one of these in a while. I actually have a big list of cases I'm excited to talk about. But today, I want to talk about about a case that brings up a number of different issues that we get asked about often. Before I get to the case, quick reminder to make sure that you like us and follow us wherever you're watching Notable Approvals on YouTube, Facebook, Instagram. And if you like what you see, you find it helpful, or know somebody who may, please hit the share button. And we're not going to be answering any questions about cases today, but you can always contact me privately about your own case. My contact information is scrolling along the bottom of your screen on YouTube and Facebook, on Instagram. If you go to our bio page, you can find it all there. If you have any questions about this particular case, please feel free to leave it in the comments. So today's case is about a client who is a native and citizen of China. She first entered the US with a visa in 2016. She married her US citizen husband in 2017, who then filed an I-130 marriage petition for her, and she concurrently filed for her green card. They did not have a lawyer when they filed. In June of 2018, they had their first interview. And I was there. I'm not sure what happened, but things didn't go as planned. It wasn't approved after the interview, so that they got called in for a Stokes interview. For those of you who don't know what a Stokes interview is, that is in New York, they call it a Stokes interview. In other jurisdictions, it might be called something different, but they have the same type of thing. What it is where you and your spouse go in for the interview and you guys are separated. So it could, either of you can be questioned first, but it's usually the US citizen is questioned first. And then you go sit in the waiting room, and then you switch. You get asked the same set of questions. After all the questions are asked, you both come back into the room together, and the officer goes through and says, here's all the questions that you gave me different answers for, and then says, please explain why you gave me different answers. And then at the end of that, hopefully, there aren't too many discrepancies in your answers, and you get an approval notice. Now, in this case, they were called in for a Stokes interview in February of 2020, but in October of 2020, the case was denied. Now, it is important to point out, and I'll explain more as I go along, on the fact that they didn't have a lawyer at this interview may have prevented the denial, but who knows? They came to us right after it was denied, and we were able to timely appeal. Now, this brings me to the first thing I want to talk about before I get to why the case was denied and what we did to show them that it shouldn't have been denied. A lot of times people will come to us after a case is denied and within the time to appeal and say, I want to appeal. And we always explain that not every case makes sense to appeal. It might not be because it has anything to do with your marriage. It might be because if you submitted no marriage documents, for example, no proof that you live together, no proof you have any joint finances together, and there's nothing we're going to be able to do on appeal to change that. So sometimes you just need to refile. Now, some people often want to forego refiling and do an appeal because they think it will be quicker or cheaper. It's only cheaper. Well, it's not even that much cheaper because it costs money to write an appeal. But in terms of quicker, that is definitely not necessarily true. And here's a good idea of the timeline for all of this, because we appealed it within the 30 days before November of 2020. And then we actually didn't even get any acknowledgement of receipt of the appeal until April 2021. It was then sent, then we had to we submitted our notice to appeal, but I wrote the appeal at that time. We got the transcript like a week after we got the receipt in April of 2021. I then sent in the appeal to the BIA. In May of 2021, we got a notice that they were forwarding the appeal to the BIA. And then it took until July of 2021 for the BIA to say, we got your appeal, and actually issue a receipt notice. And then now at the end of basically beginning of February, end of January 2022 was when we finally got an approval. So a year and 2 months later, about 3 months later. So right now, the timing, we're getting cases, new marriage petition, green card cases approved in less than a year. So, you know, sometimes it takes more than a year, you know, but in terms of if you're just doing it for timing reasons, that's not why you appeal. You appeal when there's an error as a matter of law. And what that means is if USCIS misapplied the law to your case. So an example would be they said that they were denying it because you didn't submit joint taxes. Well, although joint taxes is a good thing to submit, it's not a requirement. It's a suggestion, not a requirement. And that basis alone is not a reason to deny a case. We also can appeal it if they abuse their discretion when it comes to the facts. What that means is that the decision that USCIS came to was so wrong, so egregious, so erroneous, that it goes against the weight of all of the evidence, of all of the answers that were given. So in this case, we got a little bit of both of those things. I mean, it's all abuse of discretion, but essentially they have a legal requirement to review all of the evidence, and I'll get to that shortly. So the point that I want to make, though, is first and foremost that if you do get a denial in your case, you should, whether you have a lawyer or not, you should immediately contact one who is experienced in these matters and ask them, you know, what should I do? Now, I recommend if you're going to a Stokes interview, I recommend everyone get a lawyer because these things are complicated. They're more complicated than you think. You're going to save your time a lot of agitation, a lot of time, a lot of money if you do it right the first time. But if you decide to do it yourself, great. If you have to go to a Stokes interview, that is the time to hire a lawyer if you don't have one. And the reason is that when I go to a Stokes interview, I take very good notes. Now, in this case, I was able to write the appeal right away. Not because I was there at the Stokes interview, but because the client was able to explain to me what happened very clearly. Like, you have the denial notice and the reasons for the denial. And I go, you know, with every client, we sit there and go through and say, well, you know, why did they say this answer was inconsistent? And they tell us what happened. And we take notes. I didn't submit the appeal right away because you're allowed to wait to you get the transcript. So I was able to see, it's like hundreds of pages, but I was able to see everything that was said. But I actually had to compare what the client told me to the transcript to make sure that's exactly what happened. In this case, it was. So it made it easier, though, because everything was really fresh. She told me what happened. I wrote it down. And then the client signed the affidavits. I got the transcript. I already had my appeal written, and I was just verifying it. I've had other appeals where I haven't been there, where, you know, I typed the notes that the clients told me. I did my best to write what I could at the time, but I really had to wait to the transcript to see what happened and then sit down with the client again and figure it all out. Either way, my results are going to be the same. My appeal isn't going to be worse off. It's just always better when it's fresh, and I like to be able to get the big brief out of the way. But if I'm at the interview, it takes away the concern about the transcript. I have to wait. They're going to send us the transcript anyway because that's what the law says. But I know what happened because I was there. And also, I'll be there for the rebuttal phase where they're asking, why did you answer the questions differently? And I've actually had to step in at times and be like, look, you answered these questions differently. So it's helped that I was there, and I've been able to make sure that the officer saw all the evidence. So, a client can tell me, look, I brought in, evidence A, B, and C, or documents A, B, and C, and then it's not listed. They may have actually shown it to the officer. Maybe they just had it in a pile. So there's little things that you can do to make sure that you are giving yourself the best chance of success. So let's talk about what happened in this case and how we handled it. So first, there were evidence issues in the denial. They said, and this is again, these are common things that they say, but essentially they said that the evidence submitted of the marriage being real could easily be obtained by anyone who has a marriage certificate, and that it's not necessarily indicative of a bona fide marriage because it's limited in duration and lacks probative value. What does this mean? Well, if you've ever watched any of my other notable approvals about marriage cases where I talk about some evidence is better than other evidence, they're basically saying, look, we know you submitted marriage evidence, but all this stuff doesn't mean anything because anyone, and I tell my clients this all the time, who want to give me 18,000 pictures. Pictures are great, right? But anyone can take a picture. I don't even have to be married to take a picture with somebody. Anyone can have their mom write a letter, and your mom will write sign her name on any letter that says you have a real marriage type of thing. So not all evidence is created equally. And they're saying here, we acknowledge you submitted A, B, C, D, E, F, but this evidence isn't great. Now, the problem with USCIS's assessment of this evidence in this case was that the clients actually submitted a lot more evidence that was mentioned. And they didn't, when they're supposed to list everything that they consider, and if it's not listed, that means they didn't consider it. So, for example, they said, okay, you submitted a life insurance policy listing each other as beneficiaries of the policy. But anybody can go get a life insurance policy. Now, that is something I have seen a lot where people will, to make their case stronger, will go get a life insurance policy and just not pay for it. But in this case, they actually submitted proof of payments. So I mentioned that. Then they said, well, we see that you submitted a joint bank account, but they didn't list the dates of the joint bank account submitted. And remember, they're saying that it was limited in duration, meaning sometimes I've seen people only submit like one month, one bank statement. But in this case, there was like 9 or 10 or 9 months over 2 or 3 years, which is a lot more. And more importantly, or equally importantly, it showed regular use of the account. So anyone who is married can go to the bank, whether you got married for because you love each other or to get a green card or anything in between, can go to the bank and say, look, we're married, we want to open a joint bank account, and they will open you a joint bank account. So opening a joint bank account alone doesn't do it. But if they want to see that you're sharing your finances. So you're depositing money into the account and taking money out and doing that on a regular basis. It's always good. I always encourage clients also to pay joint bills from that account. So I pointed out all the months that were submitted. They said, well, they mentioned that they had joint health insurance. But again, it wasn't just a month or unspecified duration. They submitted like the initial and then the renewal of it. So for 2 years. Then they wrote that you submitted a lease agreement. Well, they actually submitted 4 lease agreements for their apartment, 2 separate apartments, 2 renewals for each of those apartments. They said they missed 1 of the years of joint taxes that they filed. And then the clients had submitted some affidavits from family and friends and photographs, none of which were mentioned in the denial. So step 1 was you erred as a matter of law by not considering the totality of the circumstances and all the evidence that was submitted. Then we got to the second part, which was the discrepancies. And these are, I asked spouse A question 1, I asked spouse B question 1, spouse A said answer X, spouse B said answer Y. We bring you together, explain why there's a difference. So my argument in this case was, well, first of all, they did overcome their different answers in many of these. And there was 1 or 2 where it was like, well, this isn't material. This doesn't prove that they don't know each other or their relationship isn't real. You're kind of just like, if I ask you, maybe, does your spouse drink? I'm drinking Diet Coke. So I'm thinking, does your spouse drink Diet Coke? And you've never seen your spouse drink Diet Coke before, and you say no, and your spouse says yes, and then they ask you to explain. Your spouse says, well, I drink it at work only, and you don't see your spouse at work. Well, they can't then turn that around and say, well, you don't know your spouse. You don't know what they drink Diet Coke. That's a terrible example, but I think it at least illustrates the point I'm making. So in this case, there were 10 different statements that were allegedly inconsistent or discrepant. And this was an interesting case because the first 3, it actually, it says what I said. I explained, I asked this question to both spouses and you gave different answers. During the rebuttal phrase, neither of you responded. And I asked the client, well, what happened? Well, it turns out because they didn't, this would have been a time the lawyer would have helped. They thought that the officer was going to read through the entire list of questions before they were supposed to respond and explain themselves. So after the first 3, they didn't say anything. And then they realized after that, wait a second, they kind of realized that the officer was pausing, waiting for a response. And then they started responding, and that reflects it in what the denial says as well. Now, when you go to the Stokes interview, the officer reads through a whole script and explains what it is and what the deal is. And some of them do read it very, very fast. But look, you're nervous. You're not going to hear everything. This was the first time I saw that, actually, that I can recall, because most of the cases that come in here, we initiate. So in our cases, we don't file for people who don't have real marriages. They don't get denied like this. So I don't see that many denials. But this was the first time where, it was really clear that there was something, they must have missed something in the first 3. And yeah, of course, you want to listen, but it is another reason to point out that if you have a lawyer with you, if my clients don't, after the first one, I'd be like, you guys, why don't you explain it? That's really the only thing I can do. I can't answer it for them. I can't explain it for them, but my clients aren't responding. I'd be like, guys, respond to the officer. So what I decided to do, and again, I had affidavits from the clients explaining all of this. I went through the first 3 and I explained how they would have overcame the discrepancy, or that it wasn't a discrepancy if they answered the questions at the time of the interview. So the first one, it was a math problem about, they asked their age when they met. They knew each other's birth dates, but they didn't do the math. Being good at math isn't a reason for, or bad at math isn't a reason for denial. There's another one about misunderstanding, asking about time of employment, when you met versus when you started talking. Again, these are things that if sometimes the officers actually ask the question different, and I've picked up on that before, and I've pointed that out, and it wasn't a discrepancy, but I was able to confirm that with the transcript. And then the last one was one of these where the client made an assumption, didn't know the answer. So instead of saying, I don't know, which would have been listed here anyway, made something up. And it was about the petitioner's brother who he doesn't talk to. And I was like, well, you can't really fault someone for not knowing the answer when this is not a person that's in either of their lives. Then we get through the next 4, 5, 6, 5, the next 5 discrepancies. And it did have the explanation of the clients in there. And I basically explained that, look, they explained why they gave different answers and their reasonable explanations. And so they say that you didn't overcome Instagram, you just went for a little ride. My phone fell. But they did overcome the discrepancies. So Lovey, I see your question, but we are not talking about individual cases right now. However, if you reach out to me, if you see on the bottom of the screen, because I see you're on YouTube, our contact information. If you give me a call or you send me an email, I'll be happy to discuss your case with you. And my gut instinct is yes, but I don't know until I review your case. So getting back to this case, and I want to just give you an example of when I would say that you overcome the discrepancy. So the petitioner in this case had a lot of tattoos. And the officer asked the beneficiary, how many tattoos does he have? Describe them. And she described all the big tattoos. He has like big tattoos, small tattoos, whatever. And she said in the answer, like she didn't describe them all. And she said, when asked why not, well, I didn't realize, I thought I only had to describe the big ones. I didn't realize we wanted all of them. I just figured I'd describe the big ones. Okay. And then they said something, he has one tattoo that's like a phoenix or an eagle. I don't even remember which it was, but she said it was an eagle, but it was actually a phoenix. And then the officer said, why did you say the wrong thing? It's a big tattoo. And she said, well, I don't know the difference between an eagle and a phoenix. She's from China. Her English is really good, but that doesn't mean that she knows the actual difference between a phoenix and an eagle. I couldn't even tell you what the difference is. I honestly don't even know. I'm not what are they called? I was thinking of Always Sunny in Philadelphia. Charlie's a bird lawyer. I'm not a bird lawyer. I was thinking for the actual term for a person who studies birds, but it's escaping me. The point is, that's an example. Look, she explained why she didn't explain every tattoo and why, like the big tattoo, she actually explained that she thought she was describing it properly. She knew what it was clearly, and she didn't know the difference between a phoenix and an eagle. So the last thing I made sure to point out, which was, look, these Stokes interviews, these are 10 different inconsistent alleged statements. Even if they completely got these wrong, which they didn't, there were a lot. I mean, like I said, this was like a 300-page transcript, which is common for Stokes. What about all the questions they answered right? And there were a lot of the questions they answered right pertained a lot more closely to whether or not they actually knew one another. So I pointed that out as well. So ultimately, the way you appeal these things is that you don't appeal it right to the Board of Immigration Appeals or the BIA. You send it, so they were in the New York field office. So you have to send it to the New York field office. They do an internal review and basically decide, based on what we write in the appeal, are they going to oppose it or are they not going to oppose it? Or they can actually say they want to reverse their own decision. So in this case, it was the latter. My appeal was very strong. I remember writing it and feeling very good about it. And DHS, who's the opposing party here, the Department of Homeland Security, actually said that when sent it to the BIA, I don't know why they do it this way. This is the way the procedure is, but they basically now, once they review it and they say, okay, we want to enter a new decision. We're going to reverse the decision and enter a new decision, which means they're going to approve it. But they send it up to the BIA, and then the BIA kind of has to rubber stamp it and say, okay, go ahead, and then send it back to USCIS. So again, when you ask me, is it quicker to appeal? Well, I just described a ridiculous process to you that happens in the best case scenario. Like, you might have the DHS oppose it and refuse to send it to the BIA because they don't necessarily have to if they feel that they didn't make a mistake. Or they can sit on it and not do anything, and then it doesn't go to the BIA until they act. There's all different types of things that can happen. So, this was a case that I felt strongly should have been appealed. The decision was wrong, but we still said to the client, look, we can't promise you timing wise how long this will take. And even if we're right, they could still deny it, and then you can't then appeal. There's nowhere else to go with it. You basically then refile it. And so you wasted all this time, now the money on the appeal. It's a case-by-case basis, and if you go to any attorneys or you talk to anyone about this, make sure that they explain this all to you and about your individual case, and explain why one thing is recommended over the other. I recommend, in this case, appeal. It made the most sense, but not because I thought it was going to take quicker or there were a better chance of getting approved, because I thought USCIS made an actual error. And another thing that can be really frustrating, because we're going through this right now with another client who we've appealed for, USCIS. If you were watching earlier where I went through the timeline on when everything happened, that we had mailed this out in November of 2020, and then by April 2021 we still had no receipt notice, and that's common. But when we looked to see if the filing fee was deposited, it didn't show it was, and that's when we got nervous. Well, maybe they didn't receive it, even though the case status showed it was, still pending. So we sent it again, and it wasn't until after that, I do believe they got it because I didn't resend the checks. I didn't send new checks, but it wasn't until about 5-6 months later that we finally got a receipt notice. So it could be a little stressful, and not having a receipt notice like that. And the official receipt notice, that was just an acknowledgement. Like, it wasn't even a receipt notice, it was the Stokes transcript. The official receipt notice from the BIA didn't come till July of 2021, even though all this stuff had happened. So it's also important to keep in mind, because people, sometimes they need to prove something's pending for one purpose or another, and all we can do is keep pointing to the fact that we sent it, proof that we filed it, proof that the case is still open, and your I-485 is in this entire time, which is what your work permit and your travel document are based on, are invalid while this is all going on. So if you need to work, that sometimes is a reason why it makes more sense to refile. That was a lot, but yeah, so essentially the next steps in this case is going to be, we have to wait for USCIS to send us the official approval notice, because basically they've already indicated they're approving it. BIA sends it back. USCIS has to actually issue the approval notice. At that point, it's supposed to automatically reopen her green card application. She could be called in for another interview. I talked about maybe a year ago another case like this where they're actually called in for another Stokes interview. But in that case, BIA lost the transcript. So they didn't have any record of what happened at the Stokes. And I was able to appeal it the way I did because I was there, which again is a good reason to have a lawyer, because based on my notes alone, they reopened the case. In this case, they have the transcript. I don't see why they'll need to call them back for a second Stokes. They could issue a request for evidence, but I think they are going to actually approve it. Once that occurs, the I-485 will be reopened. If it's not automatic, we have to write them a letter to tell them, because right now it's administratively closed. So that is all for today. As I mentioned earlier, contact information is scrolling across the bottom of our screen. If you have any questions about your own case, please feel free to contact us. We'll be happy to help. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching, and get our social media news. I'll be back hopefully soon with another notable approval. We've been a little bit busy, which is a good thing, because that means there's more people that we are helping. Otherwise, thank you all for watching, and have a great day.